Good morning, everyone, and thank you for joining another of our sessions of the Burness Paul Junior Energy In-House Lawyers webinar series. My name is Marianne Wilson, and I'm a senior solicitor in Burness Paul's Energy Real Estate team. I will be one of today's speakers, and I'm joined by my colleague Lorna Mackay, who's part of our rural business team. Today's webinar will focus on agricultural and crofting considerations when developing renewable energy projects in Scotland, providing an overview of key factors for developers, including drafting for natural capital benefits, and some of the implications of the upcoming land reform bill. Before we get started, a wee bit of housekeeping. Once you've joined, please ensure your mute button has been selected to limit background noise. Today's webinar won't be interactive, so please do contact Lorna or myself if you have any questions. Our contact details will be available at the end of the slides as well. Today's webinar will be recorded, and if you have any queries on that, please do check out our privacy policy on the Burness Paul website. So, what are we going to cover in today's session? We'll be looking at the importance of scoping the suite of rights needed by the developer at the outset, where there are third-party agricultural or crofting occupiers. We'll be providing a summary of these types of tenancies and other rights you might be faced with, and how to identify those at an early stage. We'll be looking at how to deliver the rights needed for the development within the relevant statutory framework and other constraints applying to different types of tenancies, including guidance on when resumption or termination of an agricultural tenancy is feasible, the role of tripartite and other forms of agreements, comments on the forthcoming changes proposed in the Land Reform Bill, and how to deliver development on land affected by crofting tenure. We'll also be touching on some pointers on the impact of the natural capital market on energy transactions and what we are seeing in the drafting for natural capital benefits. I'll now pass on to Lorna to get us started.
Thanks, Marianne. I'm a director in our rural business team here at Burness Paul, and as well as acting for farmers and landowners and tenants across Scotland, I advise commercial developers in the energy, house building and telecom sectors, working with others across the firm. I'm a Law Society accredited specialist in agricultural law, so anything involving farm tenancy of any kind tends to find its way to my desk. As Marianne said, we're going to start by looking at the rights needed by developers where there are third-party occupiers on the land. Developers will know and understand what land and property rights are needed to make a development happen. They need landowners to be able to facilitate all of the rights usually required during the option period, typically site investigations, surveys, etc. They also need landowners to be ready to grant vacant possession at the point of lease, along with the usual suite of ancillary rights, including access, etc. When you're dealing with a project on owner-occupied land, the process of identifying lost my notes. The process of identifying the rights you need. Sorry, I've just lost all my notes. It's relatively straightforward. Where there are third-party occupiers of any kind, there's an extra layer of complexity, as either landowners need to get themselves into a position where they can grant the rights needed without third-party occupier consents, or there will need to be a secondary layer of agreement with third-party occupiers. At option stage, it's possible that the written tenancy documents will include sufficient reserved rights to allow site investigations, etc. That's less likely in older leases, which tend to have less comprehensive reservations. At the point of an option being exercised and a lease granted, reserved rights will not be enough, and the landlord will need to be able to obtain vacant possession at that point. Although granting the necessary land rights and delivering vacant possession is, in theory at least, the landowner's problem, in practical terms, a developer needs to know that the landowner's contractual commitments are deliverable. A breach of contract claim against the landowner in the event that their agricultural tenant fails to remove is not a very useful remedy when there are project timetables to be met. In most cases, developer and landowner will come together to consider the position and propose an agreement with any third-party occupiers. And that agreement is usually tripartite between developer, landowner and occupier. However, negotiation of that voluntary agreement is informed by what the landowner can and can't do in the absence of agreement. So it's essential that the parties have worked that out at an early stage, i.e. what's the landowner permitted to do under any existing tenancy documents, And are there any constraints under the agricultural holdings legislation? So, types of occupancy right. The first step in working out what rights are needed and how to procure those is to establish who's on the land and on what basis. We're focusing on agricultural tenants and crofting rights today, but third-party rights on rural sites can include a broad range of interests, including the landowner's own farming or estate business operations, though generally not a major issue. There can be grant schemes, contract farming arrangements, which require adjustment as a result of the proposed project. There might also be sporting tenants. The landowner might have existing natural capital projects underway. In an ideal world, the landowner will disclose these straight off the bat, but they might not think to do so unless prompted. So it's always worth just asking the question. Turning specifically to agricultural occupiers, excluding crofters, which Marianne's going to look at, the options for securing the rights needed will depend on the type of tenancy, but it's not always obvious what kind of tenancy exists. There isn't time today, you'll be pleased to hear, to go through all the different tenancy types, but very broadly, the possibilities are a secure tenancy, a fixed term tenancy, a seasonal let, or a licence arrangement of some kind. Looking at these in turn, a secure tenancy, often known as a 1991 Act tenancy, is generally the least attractive type of tenancy from a project delivery perspective. The clue's in the name. The tenant has security of tenure, as they have the right to remain in possession after the agreed period of lease expires. The lease continues on tacit relocation. It can be passed to successors on death. I'll look at the scope for resumption and termination in a bit more detail shortly, but the headline point is that it's usually quite limited. If you're presented with an arrangement that started before 27th November 2003, it's almost certainly going to be secure, and that will be the case regardless of what the documentation might say. An unwritten arrangement commencing before November 2003 will also be secure. Turning to the next one, the next and most common scenario is the existence of one of the fixed term tenancies permitted by the Agricultural Holdings legislation. Fixed term tenancies were brought in by the Agricultural Holdings Scotland Act of 2003, and there are now a number of different fixed term tenancy types, which include a fixed term tenancy of up to 5 years. You'll hear that referred to as an SLDT, a short limited duration tenancy, a fixed term tenancy of 10 years or more, originally created as LDTs and are now modern LDTs following the last round of land reform in 2016. You might also come across one of the longer fixed term tenancies, which is running beyond its contractual term on a statutory continuation. The continuation might be for 3 years, it might be for 7 years or 10 years. That just depends on when the tenancy commenced and how long the parties have let it run on. So there's quite a bit of complexity there. Again, I'll come back to the process of resumption, but the key point with fixed term tenancies is that they do benefit from a statutory right to resume, provided there's no express prohibition in the lease itself. Termination is possible at the end of the fixed term of the contractual lease, provided that the landowner follows a prescribed double notice procedure set out in the legislation. Next possibility you might come across is the prospective development land may be let on a seasonal let for up to 364 days. These are fine from a developer's point of view, provided they're done properly and the terms adhered to. But as I'll come on to, occupation coupled with rent beyond the 364 days can leave you dealing with a wholly different type of tenancy, so just be aware of that. The other common basis for agricultural occupation could be a rent-free licence, possibly a written one, but often unwritten. Again, these are potentially fine from a development point of view, as there's no security of tenure, provided there's truly no rent, and that can be evidenced. Well-advised landowners tend to put these in place when they know there's a reasonable prospect of future development on the land. So that is good news if you find one of those when you're on the development side. I think if you can take one thing away on agricultural tenancies today, it's to beware of taking the written lease documentation at face value. It may not do what it says on the tin. The factual background has to be considered alongside any lease documents that are available. Don't assume that the landowner you're dealing with will know for certain what rights are in place. The agricultural holdings legislation is complex and there are many pitfalls for landowners. It's not uncommon for them to believe that they can deliver vacant possession for a scheme, but in fact they can't, or perhaps not as quickly as they thought. So how do you undertake that diligence so that you know what you're dealing with? As I mentioned, tenancies can start out as one thing, for example, a seasonal let, and due to the actings of the parties, morph into something entirely different, such as a longer term fixed term tenancy, or worst case, a secure tenancy if it's been running for a long time. We've seen many cases where a commercial deal's been in the works between landowner and developer over a period of years, only for it to be discovered at the point of option and lease that the written tenancy lease everyone had been relying on had been wholly overridden by statute. So what questions should we be asking? Firstly, is there any lease documentation? Well, great, that's a decent starting point. Look at the paper trail, but also look at what's been happening on the ground. As a general rule of thumb, always ask how long the tenant has been on the land and paying rent, irrespective of what the lease documents say about commencement dates. Who's in occupation of the site? Who's paying the rent? Basic, but important, more common than you think for this to be a difficult question to answer. Is it an individual? Is it a farming partnership? If it's a partnership, have the partners changed, meaning the lease no longer binds the parties? Has there been any succession following death of a tenant? If so, were the statutory rules followed at that time? From the developer's point of view, any anomalies are best identified early and can, in some cases, present an opportunity. If there's no rent from a development point of view, this is usually good news, but beware of rent in kind. Relatively rare, but can be enough to result in a licence being treated as a tenancy. Also beware of licences that are leases by any other name. We occasionally see what are licences, but sneaked in there with a peppercorn rent, £1 of AST, and that just leads to uncertainty. Other important question, when did occupation commence? Has it continued beyond the contractual dates? This makes a huge difference to the type of tenancy you might be dealing with. As a general rule of thumb, if it commenced before November 2003, it's likely to be secure. If there's any known occupation before the contractual commencement date, query this, as back-to-back arrangements can sometimes be completed together and treated as a longer-term tenancy. Continued occupation beyond the contractual term will convert one kind of lease into another, giving the tenant a stronger tenancy and potentially a stronger hand in commercial negotiations. To avoid a continuation, particularly in the case of fixed term tenancies, it's not enough simply to advise the tenant of the LDT or the MLDT that the term won't be extended beyond the original period. The landowner must follow a statutory double notice procedure to terminate. So if, as developer, you're relying on the landowner taking those steps, make sure you've got them on the hook to do that and serve those notices. If they don't, the statutory continuation process kicks in automatically. So now we know what we're dealing with. You've done your diligence on what rights exist, and you can look at the process and timescale for actually securing the rights that you need. With the benefit of your early stage diligence, it should be possible to liaise with landowners and their advisors on the best strategy for procuring the rights needed from the occupiers. The interests of landowner and developer are generally aligned on this. In most cases, the outcome will be the landowner approaches their agricultural tenant to agree a voluntary deal. This isn't guaranteed. Not all tenants will be keen on development on their farm, even if there are financial incentives. In all cases, the parties need to know their backup position and under statute and existing contract in case it's not possible to agree the voluntary deal. In most cases, securing rights where there's a seasonal let or licence is straightforward, so I'll focus on the position for secure tenancies and fixed term tenancies. Looking firstly at how to resume land, which simply means taking land out of the tenancy. For secure tenancies, there's no statutory right to resume. Resumption's wholly governed by contract and common law. Resumption clauses in written leases are fairly common, so provided you're taking land out for a non-agricultural purpose, resumption is usually possible. If the lease is unwritten, there will be no right to resume. The contractual timescale can vary lease to lease, but in practical terms, the statutory rules on compensation for tenants mean that the notice period can't be less than 2 months. There are changes proposed in the Land Reform Bill, which may affect this timeline, pushing the period for getting vacant possession to at least a year. In addition, the amount of compensation tenants are entitled to on resumption is expected to substantially increase once the Land Reform Bill, currently going through Holyrood, is enacted. We're keeping an eye on how this is developing and it will have an impact on how we structure project documentation. It may also impact on commercial terms. The right to resume isn't wholly unrestricted. The common law provides that a landlord must not commit something known as a fraud on the lease. There's lots of cases in what a fraud is, but for today's purpose, it simply means that a landlord can't resume so much land that the remaining leased area is unworkable as a farming unit. Again, this is an issue for the landowner principally, but as a challenge by the tenant against the landlord could result in a lengthy land court action, we need to be alert to the risk on the developer side. A challenge of this sort would be a major project delivery issue, so can be a key driver in pushing the parties towards a voluntary agreement, even where there is a clear contractual right to resume in the lease. Turning to the scope for resuming land from fixed term tenancies, unlike secure tenancies, there is a statutory right to resume, so you don't need a written right in the lease. But these already have a longer lead-in time than the 2 months for secure tenancies. Resumption from a fixed term tenancy is possible if you get planning permission for the non-agricultural use and you give at least 1 year's notice. So those timescales always need to be factored into the development timetable if the landowner intends to rely purely on statute to deliver what's needed. The statutory right of resumption will not apply if there's an express prohibition in the written lease, so that should always be checked. And the same considerations relating to fraud in the lease apply to fixed term tenancies as they do for secure. So moving on from resumption and looking at termination more generally, is it possible fixed term tenancies can be ended on their contractual date if procedures are followed, but that may not tie in with project timetables. Otherwise, termination is limited to fault-based issues. Very few opportunities to terminate a secure tenancy. One potentially useful exception is where planning permission affects the whole of the holding. For a non-agricultural purpose, the landowner can serve an incontestable notice to quit. Can be useful but isn't always feasible in energy projects unless the footprint of the development affects the whole of the holding. To clarify, that process isn't available to fixed term tenancies. I'm going to rush through here because I'm conscious of time. I think the pitfalls of flagged so far help illustrate why in most cases we end up putting in place voluntary negotiated agreements with occupiers. Benefits are certainty and timescales in delivery, scope to provide for staged development and micrositing, multiple resumptions, flexibility on the land affected, all covered by one agreement. You can agree liability for compensation at an early stage and enable some control of occupiers as we can seek undertakings as part of the deal, restricting the occupier from objecting to planning, etc. Although a negotiated deal may appear more costly in terms of financial incentives offered, if you can get the quantum right, the saving and project timetable coupled with certainty of delivery are likely to make that worthwhile. We usually see these as being tripartite, has the added benefit of direct enforcement rights by the developer, visibility for the developer, and clarity on the parties' rights and obligations during the option period, bearing in mind the project land remains part of the tenancy during that period. I'll hand you back now to Marianne because I think I've gone over time a little.
Thanks, Lorna. I'll be discussing the interaction between crofting and common grazings with proposed renewable energy developments. With more than 700,000 hectares of rural land and crofting tenure in Scotland, in our experience, much of the land for new development in Scotland may either be held in crofting tenure or otherwise affected by the crofting regime. Often the easy, clear and unoccupied land in the crofting counties in designated areas is already developed or under option. As a result, developers have key restrictions and considerations to take into account when trying to develop on croft land and common grazings, and we'll be discussing what options are open to a developer to deal with these. I'm sure many of you will probably be aware as to what a croft is, but just in case you aren't, it's defined as a relatively small agricultural land holding situated within one of the crofting counties or designated areas, which is normally held in tenancy and which may or may not have buildings or a house associated with it. Unlike agricultural tenancies, it is the land itself that is deemed to be a croft. It's not only driven by the form of agreement that's in place between the landowner and any tenant. Crofted land is governed by restrictions which are stipulated under a sea of legislation. Particularly important here is the Crofters Scotland Act 1993. Under this, crofters are either to cultivate the croft or to put it to some other purposeful use which would not adversely impact the croft itself. the wider public interest, interests of the landowner, or any adjacent land. As a result, the development of crofted land for renewable projects may conflict with one or more of these duties. It is not just crofted land, though, that can pose difficulties for such developments, but also common grazings. As it stands, there are over 1,000 distinct common grazings in Scotland, making up around 500,000 hectares of land. Again, many of you will be aware as to what a common grazing is, but if not, it is defined as areas of land used by a number of crofters and others who hold a right to graze stock on that land by virtue of their tenancy in a croft. They are managed by grazings committees and are subject to the shared use and shared management of a number of crofters. So where we have a common grazings, we likely have a number of crofters involved. Under the Crofters Reform Act 2007, rights were introduced for crofters and graziers to use common grazings for purposes other than just grazing itself, which includes the development of renewable energy projects. So, how do we go about dealing with crofted land and common grazings for the purposes of our intended development? Firstly, I'll touch on decrofting briefly, which essentially removes the land from its designation and from crofting control permanently. As such, this option can't be pursued where there's a crofting tenant in occupation of the land. Decrofting involves notifying the Crofting Commission, which is the non-departmental public body which monitors crofting matters under the responsibility of the Scottish ministers, and thereafter making an application to the Land Court. In current times, it's not as frequently used anymore due to the fact that the croft needs to be vacant, but also that it's a permanent designation change of the land. As such, I won't be focusing too much on decrofting, instead moving to the other options open to developers, starting with resumption. With resumption, the land is temporarily suspended from the crofting regime, but it does not involve the permanent relinquishing of the crofter's rights. Resumption is done by way of an application by the landowner specifically to the Land Court. In practice, we see it usually that the application is made by the developer's legal team, but signed off by the landowner and their legal team. The relevant application is made for a specified period of time, which would normally be the lifetime of a development, including construction and decommissioning. The developer can make an application to extend, but this will be subject to the Land Court's view as at that stage, so there's no guarantee that it will be granted. The guidance on the legislation stipulates that a form of minute of consent should be obtained from the crofter in order to evidence their consent on the presumption that they do consent to this. And all of this is then put together and notified to the Crofting Commission, who can object to the proposal. There are no specified timescales for objection, but we usually see around 4 weeks for the Crofting Commission to respond. The Land Court then has to be satisfied that the application meets the legal test, which is under Section 23 of the 1993 Act, if you're at all interested. They need to be satisfied that the development is for a reasonable purpose. And this includes the using, letting, or disposing of land proposed to be resumed for planting, the construction of roads for vehicular traffic from the croft to the public road, also includes the generation of energy, and also any other purpose likely to provide employment for crofters and others in the locality. So as we note, the generation of energy and electricity is explicitly included as a possible reasonable purpose. But applicants still need to prove that the generation of energy in this circumstance is a reasonable purpose with regard to 4 factors. And this is the good of the croft, the good of the wider estate, the wider public interest, and the interests of the crofting community in the locality of the croft. And to evidence this, we've seen that applicants have pointed to the economic benefits for the area and the community if the developer is paying into a community benefit fund, for example. And also developers have pointed to the government's general net zero targets to illustrate the proposed development as a reasonable purpose. But ultimately, it is still to the Land Court's discretion as to whether to grant the resumption. The court needs to be satisfied the development is viable and is likely to produce a net benefit with regards to the 4 factors previously mentioned. Now, some of the advantages of using resumption is that the land is restored to the landowner's control, albeit for a specified period of time. Additionally, applications can be made fairly quickly where all parties are in agreement. However, that's maybe not always the case. Next, I'll be touching on schemes for development. Whereas resumption temporarily removes the land from crofting tenure, which changes the status of the land, the schemes for development temporarily suspend the rights of the crofters to plant and cultivate the croft, but there is no change to the status of the land itself. Historically, funders of renewable projects would favour resumption over schemes for development due to what was seen as an increased level of control that was obtained for the landowner and indirectly the developer. But as developments have grown in complexity and size, gaining resumption orders against each of the crofts affected is no longer frequently feasible. For example, we've seen it most recently where we have potentially a small footprint for wind turbines for, I said, a given project, but there is a large wind protection zone that is needed. Proceeding with a resumption would mean that the entire area, including the large wind protection zone, would be taken out of crofting tenure, which the Land Court won't generally favour. Whereas schemes for development could allow for the wind protection zone area to continue to be grazed by crofters and graziers while providing the necessary rights over the specified turbine footprint. For schemes for development, the landowner or the developer can make the application, which means the development has greater level of control from the outset, but the application cannot be amended after it's made, and it needs to be quite significantly detailed. It usually necessitates planning is granted prior to the application being made. Otherwise, the level of detail that's required is not yet fixed. We've seen in the past that even a variation to the tip height of a turbine has been shown to need a new application to be submitted. Some of the elements that need to be shown within a scheme for development application are the plans for development, albeit micrositing is permitted, details of the timetable and method of construction, details of the anticipated date of commissioning, details of anticipated lifetime of the development, a statement of the expected total capital cost of the development, statement of the method for securing necessary finance, and a statement of projected profits, which you'll appreciate many developers may not be, first of all, able to ascertain that level of detail at an early stage, but may not also want to disclose that level of detail at an early stage. For schemes for development, parties do not necessarily need to have consent of all the crofters involved. If the developer does have consent from all the parties, this is intimated to the Land Court rather than submitting a form of application. But if they don't have the consent, they would make the application to Land Court in much the same way as they would do for a resumption. With a scheme for development, it needs to be notified to both the Crofting Commission and also publicly notified, which, given the level of detail that is needed for the application, may not be favourable for many developers. The application is then considered by the Land Court with a slightly different legal test. First, and as with the other legal tests, the development is to be for a reasonable purpose. The granting of the scheme must not be unfair, which will be assessed on a site-specific basis and is a separate matter to that of planning. The Land Court does not treat this as a second bite of the cherry for planning objections. It must be specific to the community and the given site. The scheme needs to provide for fair recompense to each member of the crofting community affected by the development. The development needs to show that it would benefit the community financially, and the development needs to show that it is likely to otherwise benefit the community generally. If approved by the Land Court, consent for the scheme for development will last the lifetime of the project. The land remains in crofting tenure throughout, and once decommissioned, it will simply revert back to the crofter. Lastly, and conscious of time, I will touch very, very briefly on Section 5.3 agreements, which are often used in conjunction with resumptions and schemes for development. Where a crofter seeks to make an agreement that would deprive them of their rights under the crofting regime, the agreement will only be valid and binding on successors if it has first been approved by the Land Court, which will often be supported by a Section 5.3 agreement. This is used to function as a form of contracting out of the protections that are given to the crofter under statute. And they should generally be considered if we are looking to enter into any kind of resumption or scheme for development to help with the Land Court application. I will be moving forward just quickly to chat through some of the key takeaways from this. We would say that community and local stakeholder engagement should be treated as a priority for developers. It greatly feeds into any land court applications and how this will be viewed by the Crofting Commission and Land Court. We'd also say that if dealing with a croft, parties will have no option but to go to Land Court, even where all parties are in agreement. So developers need to be aware of the time and cost that this will incur. I'll pass back to Lorna, who is going to discuss drafting for natural capital benefits.
Thanks, Marianne. We're slightly over time already, so I'm just going to rattle through a few points on natural capital benefits. Many projects now need to provide for natural capital benefits, usually in the guise of habitat management works or biodiversity requirements, which can be difficult for developers to balance against landowners' interests when agreeing project documentation. Landowners are generally becoming much more savvy about potential non-project benefits arising in the natural capital market, and they're looking to reserve the ability to exploit their property via any additional commercial opportunities which might come their way. I think there's no real settled market position on these types of issue yet. Each situation will turn on what the actual planning consent is requiring. The usual developer approach is permissive. We prepare the documents and frame them to ensure that the developer has sufficient land rights to fulfil the planning obligations. And these typically have provisions to deal with any reasonable landowner concerns around that type of activity. The usual landowner approach is simply to limit the land take given to the developer early stage to pin down what is actually needed by the developer. At option stage, consultation is needed with the landowner on the planning requirements. Landowner will usually seek to limit the scope of the developer works to precisely what's needed to compensate for or mitigate the environmental or ecological impact of the project itself, rather than give the developer a broader right to undertake habitat works. Some landowners have sought to ensure that there's commercial benefits attaching to mitigation works. These flow through to the landowner. We're generally resisting that on the developer side. Until we see industry norms crystallising on this, we're just working through each development as it comes and adapting drafting to fit. A couple of things just before we round off. We're seeing drafting where we try and pin down the where of where the works can be done, and that then allows us to restrict the landowner from doing anything on that area which would prevent the planning conditions being delivered. And generally requiring parties to work together to facilitate the potential for natural capital type projects on the land. Usually that means that if the landowner is taking forward a natural capital scheme, that's fine, but if there's any material adverse impact on the energy project, then it shouldn't progress. We're also starting to see specific rents for habitat management works and the like, forming part of heads of terms and things. So we're having to draft for that too. We're a few minutes over now, so I'll, I think, wrap up there. If anyone's got any questions on the natural capital side of things, do get in touch, but I'll hand back to Marianne. Thanks very much for listening.
And with that very swift finalisation there, I'd just like to say, if you want to hear more about any of the topics that we didn't manage to go into full depth on today, if you have any specific queries arising, please do reach out to one of the team. We'd be delighted to hear from you. In particular, today we've covered the position in Scotland, but if you have any queries on the position in England and Wales, please do reach out to our brilliant rural business and also the English real estate teams. As discussed, our session today has been recorded, and you will shortly receive an email with a link to the recording of this session. In that email, you'll find a separate link to register for further sessions and to learn more about the programme. Please do use the link to check out these upcoming sessions and book your spots in advance. Our next session on the 24th of September will focus on deal and consideration structures in a renewable energy transaction. Once again, just want to say thank you very much for joining today's webinar, and we look forward to seeing you at one of our future sessions.